Desiree Kamba and Ruben Kamba.
I'm here, Your Honor.
Okay, good morning, Mr. Kamba. Mr. Kamba, you're here today on a motion for contempt related to the non-return of your child. And I was just double checking when I was looking at the file yesterday. I was looking at service. Looks like there was an order allowing service by mail to occur at an address in Rochester. And
Yeah.
did you file a return of service indicating that the documents were mailed to that particular address?
No, I was gonna see if we could move this to next week when I have the documents sent.
Okay. All right. So you're planning on mailing them this week sometime?
Yes.
Okay. Let's do this. The turnaround time between now, if you haven't already sent it, my preference would be to set it to the 18th of September. That way, when you mail it, you'll generally allow 2 to 3 days for mailing. Say if you were to mail it today, then it would potentially arrive on Saturday. Well, maybe the 11th. Let me take a look at the 11th. Just one moment. We can do the 11th. Would you be able to mail that today?
Yes, Your Honor.
Okay, let's set it over 1 week. We'll set it over 1 week to the 11th of September at 9 o'clock.
Okay, thank you.
Great, we'll see you then. All right, both parties are present. We have Mr. Ruby present. Good morning. And we have Ms. Granza here. Good morning. Just wanted to let the parties know, Ms. Carranza just recently entered into drug court, which we're excited and happy about. I think there's a real concern for appearance of fairness, not necessarily actual fairness, but appearance of fairness. Just with drug court is a kind of a special vehicle in that I'm the drug court judge right now, and so part of my job is to really be an encourager and recognize people for the great things that they're doing in drug court, and I'm all in on that. And I think that if I was in Mr. Ruby's shoes or in any other person that's on the opposite side of a case, there would be concern that judge is like a big cheerleader for the person that's on the opposite side of the litigation. So I think the optics are tough. So what that means is that I'm going to recuse myself from hearing the case, and then we'll set it to a docket in which another judge who's not doing the drug court could hear the case. Yeah. So I can't go forward with the motion today, but generally I would like to look at setting it to it'll be a Tuesday docket, either at 9 or 1. And I'm just going to double check with Madam Clerk. Based on the cause number, it ends in an even number, which that would be, do you know? 9 a.m.
10th is closed.
10th is closed. Okay. Is there any concern if we were to just set it to next week and put it on the 1 o'clock? Okay. Let me check with you all. So we're looking at next Tuesday, which would be the 10th, and it would be at 9 a.m. Are you available on that date?
Yeah. 9 a.m.
Pardon me, 1 p.m. Sorry, 1 p.m. on the 10th.
Tuesday, the 10th at 1 is. We have
Drug court.
at 1:30.
Yeah, that's right. So I think we probably need to avoid that. So let me just check with the parties on if we could do that. And Madam Clerk, you said on the 10th at 9 a.m. it's closed. So we would have to look at the 17th at 9 a.m. So Tuesday, the 17th. Does that work for your schedule? Yes, sir. Does that work for your schedule? Okay. We'll set the matter over to the 17th of September. That's a Tuesday, and that'll be at 9 o'clock. So we'll just reconvene then with a different judge. Okay. Any questions? Okay. Thank you. Looks like Ms. Vorse is making her way up. I'll ask if Jack Carnahan is on the line. Jack Carnahan. All right. I'm not hearing a response from Mr. Carnahan. I'm just going to check the participant list, see if his name is listed therein. Jennifer, Julie. I don't see it. Mr. Carnahan, if you're here, if you'll please state good morning and state your name. All right. Not hearing a response from Mr. Carnahan. Mr. Carnahan, you may be muted, and that's why I'm not hearing you. If that's the case, make sure you're unmuted and then state your name, please. Good morning to you, Ms. Vorse.
Good morning.
Ms. Vorse, you're here today for a motion for appointment of a guardian ad litem, correct?
Yes.
Okay. And it sounds like Ms. Day had previously worked on the case.
Yeah, she was involved since Jessica was taken in guardianship court.
Okay.
And so that's why I asked her to be
appointed.
Yes.
And I'm here, Your Honor. Questions.
Oh. Welcome, Ms. Day. All right. So I don't have any issues with that. I think there's general continuity that's achieved when we have a guardian ad litem that's worked on a case before, and it's more efficient, I think. Let me double check with Ms. Day. Do you have any concerns if you're to be appointed to this matter as a guardian ad litem? It's a county pay case.
No, Your Honor, I think that's appropriate given my history so recently with the parties and the child, that there's a familiarity there with everybody involved. I think that's appropriate.
Okay. All right. Very good. And just double checking, Ms. Vorse, you on your motion, the items that you're wanting the guardian ad litem to chime in on or investigate are with whom the child should live, the parenting plan,
The whole shebang,
SED issues, mental health issues.
everything, yeah.
Okay. All right.
I just want what's best for my daughter.
Right. Right. Okay. So let me just double check off a couple of things here. Okay, I'm fine with the proposal. Let me just touch base with Ms. Day as far as dates and the like. So we're looking at a time frame of at least 60 days before trial. There's no trial date set currently in the case.
That's correct.
So generally, let's take a look as far as, do you have any proposed dates that you think, just with your familiarity with the case, Ms. Day, that you think you'd be able to have a report completed?
I should be able to have it by the early part of October, so 30 to 45 days to write the report and then set court thereafter.
Okay, so 45, so looking at. What about November 6th for a review of the guardian ad litem report?
That's perfect.
Okay, Ms. Vorse, are you okay with that?
Yeah, is that a Wednesday?
It is.
That's
Okay, so we'll put the report due date for November 6th, then it'll be on the 9 a.m. docket. That's a Wednesday. And I will go ahead and sign off on that proposed order.
Am I required to serve Mr. Carnahan with anything further?
Related to this guardian ad litem appointment?
Yes.
Let me just double check. It would be helpful in that if Mr. Carnahan was given a copy of this document, then it tells him what he needs to do. He says all parties must serve the guardian ad litem with notice of any court proceedings or proposed agreement, copies of any documents that they file in the case.
Okay, I can have him served sometime within the next month and a half, so.
Okay. All right. All right. Okay, any other questions? Okay, Ms. Day, any questions on your end?
No, Your Honor.
Okay, I've signed off on that order. Thanks.
All right, thank you.
Thank you.
Mr. Jensen is here, making his way forward, taking a seat, and I'll ask if Ms. Rhodes is present. Megan Rhodes or Ms. Holder. So our last hearing, Ms. Holder was present, and looks like Mr. Lawrence is here. Mr. Lawrence, good morning to you.
Morning, Your Honor.
Morning. This is Mr. Jensen's motion for a hair follicle test, correct?
I think this was added to, we were supposed to do the parenting plan, like the final, what you think the proposed parenting plan should be.
Right, and we talked about last time, I think, and correct me if I'm wrong.
I had to do a
Declaration. Yeah. And where are you in that process?
I turned it into the court, and I gave Keith and Amanda Holder both a copy.
And when did you file it?
Last Friday.
Okay. All right. So with just so you know, kind of timeframes, with the holiday on Monday, when it takes a few days for processing in the clerk's office, so it hasn't yet hit my court file yet.
Okay.
So I don't know what your declaration says.
Okay.
And then looks like there's a note here in the Zoom chat. Let me just see. It says, Your Honor, Ms. Holder is in another hearing in Clark County. And that's from her law firm. So probably what we should probably do, Mr. Jensen, if you don't mind, we'll just pause for a bit until she can come into our case, and then I'll recall your case.
Okay. And is there any, no, right. I was going to say, how can I get you the declaration right now? But
it would be difficult in that I hadn't kind of read it and connected with other things. And so when we come back, we'll discuss that. So if you'll pause for a bit, and then once she's on the line, and to the person who sent in the text, if you could just let us know when Ms. Holder's here, and then we can call the case and address it.
thank
Great.
you.
Thanks for your patience. Thanks, Mr. Lawrence. Here. Okay. Well, welcome to Mr. Connor. And we have Ms. Russell from the state. Good morning to you.
And Beth Fellows, GAL, is present as well.
Perfect. Thank you, Ms. Fellows. All right. My understanding is that today we're just slated for a just kind of early review with the GAL to make sure that the parties have contacted her, they've shared information, they've got things rolling. So I'll turn the time to Ms. Fellows if you can give us an update, please.
Yes, Your Honor. I have had contact with both parties. In fact, they were working on a agreed temporary parenting plan. The mother asked if, they agreed if they needed to have the GAL do the investigation. I looked over what has recently been filed, and after talking with the father, who is the one that put forth a motion for the GAL, I do believe that it is in the best interest of these boys that the GAL investigation moves forward. And I have talked to both parties, and they do understand and they do agree. So there's that. And then I needed to bring this to the court's attention is that the order that Your Honor signed on August 7th has the GAL fees backwards. It should be 45% paid by the petitioner and 55% paid by the respondent. And this is reflected in the minutes of that same date. So if you
Okay.
could possibly do an amended order for me.
Sure. Okay. Thanks, Ms. Fellows.
Yes.
Mr. Connor, any input you have on any of those comments or anything about the GAL report and review?
No, just I guess my update would be that Rocio called me yesterday. She told me she wasn't going to be in court this morning. And she also suggested that basically we completely flip the parenting plan, that I have the boys Monday through Friday and she have them on the weekends. So basically where I'm at presently is I'm trying to look at schools to enroll Leo in to try and completely flip that. It's really too bad that this happened as school started, not ideal timing. She understands that too, but that's kind of what we're looking at and agreeing upon, at least for now. And that's what I know is going on.
Okay. All right. Thank you. And then regarding Ms. Fellows' correction of the payment arrangements, do you agree that I got that backwards? It should be 45% petitioner,
Yeah.
which is her, and then 55% you.
Yeah, that was what you said.
Okay. So I'll correct that. We'll do
And-
what I did. Go ahead,
Your
Ms. Fellows.
Honor, there was one other thing. This information the father shared just now is absolutely new information. The concern that I have is that these parties may come to an agreement at one point and then somebody gets their nose in a snit and then they end up reverting back to the parenting plan from 2022. The big concern that I have is that parenting plan has dad's time supervised. So I'm not sure if you could do a bench order that says everything is in place except that father's time does not need to be supervised, which would also be helpful in my investigation.
So, Ms. Fellows, with regard to your suggestion of an order that says that, notwithstanding whatever arrangement the parents come up with, whether the kids are with mom Monday through Friday and dad on weekends, or dad Monday through Friday and mom on the weekends, that there be an order stating that father's time is to be unsupervised.
Correct. And that is in the temporary parenting plan that they had agreed to and they had forwarded to me. That was the big difference that I noticed, is that they both had agreed that father's time should not be supervised.
And the reason you're wanting some type of order is that there's concern that it would be revoked or pulled.
Yes.
Okay. Mr. Connor?
Yeah, I agree. Rocio and I have been working on for the past week or so a parenting plan that reflects that. The last I had known was that I had signed that parenting plan for her to turn into you guys. And then she called me yesterday, basically turning everything upside down. If
Okay.
that makes sense. But I agree with Beth that we should have one that basically says what it looks like now, which is not supervised in them here on those days.
Okay. All right. Thank you. I'm taking a quick look at the August 12th, 2022 parenting plan. And that's the most current one, I understand. And I'm just taking a quick scan of that for that language.
It's on page 3. Father shall have visitation with the children every week at his parents' home, supervised by the paternal grandparents.
And your recommendation is that for now that should be unsupervised, no matter what his time is.
Correct.
Okay. And again, just the basis of that, Ms. Fellows, is for concern of just kind of for lack of better terminology, kind of emotional flip-flopping?
Yes, yes, Your Honor.
Okay. All right. Bear with me one moment. I'll ask again if Rocio Camarena is on the line. And if you are, if you'll please unmute and state your name. No response. I'll follow that suggestion, and I've written a bench order that reads: respondents' parenting time shall be unsupervised from here forward until otherwise amended by order of the court. So
Thank you, Your Honor.
we'll file that. And other than that, any questions or issues on your end, Mr. Connor?
I'm kind of just trying to reel and figure out what's going on some level with what she called me and said yesterday. I didn't really know how much to act on any of that. I figured her not showing up today was indicative that she meant what she said in the conversation we had yesterday. And so I'll just kind of proceed to try and work with Beth, but also trying to find a situation for schooling for Leo so he can, and they could come live here.
Okay.
And I will follow up today with both parties and try to get something figured out as well, Your Honor.
Very good. I appreciate that. And I'll make sure that the amended GAL order is filed reflecting the correct division of payment.
Okay. Thank you, Your Honor.
Okay. All right. Thanks, everybody. That'll conclude the matter for today. Thanks.
Thank you.
Let's go back to the Megan Rhodes and Christopher Jensen matter. Cause number, we have Mr. Lawrence on the line. The guardian ad litem, Ms. Holder, is now present, and Mr. Jensen is still present. Let me just go back to my notes one moment. Earlier, Ms. Holder, I called the case, and your assistant or colleague kindly let us know you're in a different matter in Clark County. And while you weren't here, I talked to Mr. Jensen just a bit, and I indicated that I thought we were there today for a motion for a hair follicle test, his motion. And he indicated that that we were also here to talk about the parenting plan. He said that he submitted a declaration in support of his version of the parenting plan. I told him I hadn't received it yet. He indicated he filed it on Friday, I think. And I indicated that there's sometimes a lag time, especially with the holiday on Monday. So I had not yet read it. And so at that point, we basically took a break, and now you're here. So my understanding from our last hearing is that the parties were going to be submitting declarations in support of their respective positions on the parenting plan. I haven't seen anything filed since. Mr. Jensen did file, but I haven't seen it yet. But I haven't seen anything filed by either party since that last hearing on the 14th of August. So that led me to believe that we were here simply for his motion for the hair follicle test. Ms. Holder, what's your take?
Your Honor, I did receive Mr. Jensen's paperwork for his declaration in support of his motion for hair follicle test. As far as submitting anything for the parenting plan, my client has already filed everything that we already need, and we are happy to stand on those pleadings and adjudicate the case based on what we have already filed. I did not believe it was necessary to bill my client for any unnecessary expenses other than what had already been covered. And I am happy to defend against Mr. Jensen's motion for the hair follicle testing based on what we have already filed before the court.
Thanks. So let me touch base with the parties then. As far as addressing the parenting plan and having consideration of Mr. Jensen's declaration, are the parties available next week?
Yes.
Okay. Ms. Holder?
Yes, Your Honor, but we're going to run into the same issue. The case I was just in has also had a set over to its next week, so I am happy to appear, but I might be a little late again.
Okay. Mr. Lawrence, on your calendar, September 11th, are you available?
Yes, Your Honor.
All right, let me just confirm one item on my end. All right, sounds like everyone is available. So we'll set the parenting plan issue over to September 11th at 9 a.m. and we'll review it at that date. Then that takes us to Mr. Jensen's motion for hair follicle testing of Ms. Rhodes. Mr. Jensen, go ahead and tell me why you want that and why you think that's important.
Well, I just know Megan, and I know that when she's single, she tends to party a lot. I submitted the GAO report, which I thought was enough from her case with Thomas Bailey, and it said that both parties had substance abuse issues. Then Ms. Holder said that they wanted to look further into the GAO report. She did submit a hair follicle test though to me from June, which is a while ago. I've been trying to get one since we started this thing, or since I took one, and so I don't know why they didn't tell me that they had already did one and made me do all this work, but I mean, here we are.
So I reviewed the hair follicle test, I think it was from June 7th.
Yes.
So with that having been submitted, are you still interested in a hair?
I would like
follicle?
another one, yes, because that was, 4 months ago. I'm willing to take another one too as well if she wants to contest that. But
And the basis for requesting is that you indicated that when she's single, she tends to party a lot, and they're
well, yes, and me and her both had substance abuse issues together. The difference is I went to treatment. She had been pregnant for going on 2 years almost. She had our daughter Nora, who we're here with now, and she was pregnant again with one of our daughters that she had lost, Ruby. So she didn't party, and it was a problem that I kept partying. So I went to rehab to better myself. She was pregnant, but
So what you're saying is that you went to rehab and then she stopped because she was pregnant?
yes,
Okay. And then is your concern that now that she's not pregnant, then there's not maybe that wall or barrier to not using?
correct.
Okay. Anything else on that motion?
That's it, sir.
Ms. Holder?
Yes, Your Honor. As far as Mr. Jensen's motion, it was basically just a statement and asking for a hair follicle test. And as he just admitted on the record, that has already happened on June 7th. My client has never been ordered to take a hair follicle test. She did that completely voluntarily. Even Keith Lawrence did not recommend that she take a hair follicle test. She's gone above and beyond in what she needed to do to provide the court with documented evidence that she does not have a substance abuse problem. As far as Mr. Jensen's allegations go, that is all they are. They are allegations based on what he has believed and what he has perceived. And he has not submitted any documented evidence himself that there's a problem. No text messages, no third-party statements, no videos, nothing of her having a substance abuse issue. Then he goes on the record today and also says that, she was pregnant with their child, Nora, who's at issue in this case. And then there was another pregnancy. And during that time, because she was pregnant, she was no longer partying and using drugs. And so that's at least a documented period of 2 years where she has not used any kind of drugs, if in fact she had a substance abuse issue at all. Did Your Honor have a chance to read the GAO report that was filed in the other case with Thomas Bailey?
That was the one that Mr. Jensen filed with his motion?
That is correct, Your Honor.
I glanced over it. I didn't spend a lot of time on it.
Yes, Your Honor. And if I may, I believe the reason that you did not see a need to spend a lot of time on it is there was just not a lot of substance there. Again, no documented evidence of my client having a documented substance abuse issue. My client contends that some of the statements that were made in there, such as her meeting her former significant other at AA, are not true. They met as high school sweethearts. Again, my client has gone above and beyond. She did a hair follicle test that came back negative in June. Hair follicle tests, as we know, are indicative of about 90 days of behavior and of activity. And so if she was to take another hair follicle test today, that would prove that she was not having a substance abuse problem for another 90 days, which then adds on to the 2 years that Mr. Jensen has alleged that she does not have a substance abuse problem. So if the math adds up, that would indicate for about 3 years now, she has not had a substance abuse problem. And she has not been in rehab. Mr. Jensen has, which is why he was ordered to take a hair follicle test and why he was recommended to take a hair follicle test in UAs, which is why, and we will get to next week on the parenting plan, there's not litigating that issue now, but 191 factors would be appropriate. 191 factors have never been appropriate for my client. And again, she's gone above and beyond. She's proven, quite frankly, beyond a shadow of a doubt, which is not even a standard she needs to prove in this court, that she does not have a substance abuse problem. All the allegations against her are baseless and just that, allegations with no proof.
Thank you, Ms. Holder. Can I ask you a question on the hair follicle test that was accomplished on June 7th? It was negative for the 5 listed items. It was positive for ETG or alcohol. So my question with that is that, sometimes sobriety is an ebb and flow. Sometimes people stop using maybe the harder drugs and turn to alcohol, and then that's abused. So there's concerns that, if a person's sober, and if you're not, and if you're still using alcohol, then you're not sober. And that I think the general idea is that you're still at risk of use of drugs if you're still using alcohol, because that's generally a nice, easy way to slide in. You get drunk and you call your friend, and then all of a sudden you're smoking meth or take a line of cocaine. So
That was also my concern, is she failed for alcoholism.
So Ms. Holder,
Yes.
can you address that?
If I may. There has been no documented history of my client having a substance abuse problem, which is normally why a hair follicle test or a UA would be issued. She has not had a DUI. She has not had a problem with the law. Mr. Jensen has not put any evidence forward that she was in inpatient or outpatient rehab for alcohol addiction. It would be, quite frankly, bad public policy to just make people take UAs and hair follicle tests for the allegation that they are law-abiding citizens occasionally having alcohol. Again, he has not put forward any substantive evidence to suggest that she has a substance abuse issue and puts the child at risk or is unable to perform her parenting duties. These are all things that he has alleged he had seen during the course of their relationship. They are no longer together. And during the time that they were together, if he had these concerns, he could have at least provided a shred of documentary evidence, a picture, a text, something, and he put forward nothing, just his own words on paper that she has a problem. But again, Mr. Lawrence did not recommend that she get a UA or a hair follicle. And so I do not believe the court should ask that she has one or take a hair follicle test when she has already done it.
I was looking at Tina Day's report from January of 2019 there, and this is included within Mr. Jensen's motion. It says both parents should be restricted from being under the influence of alcohol/marijuana or any illegal substance during their residential time. Standard UA/hair follicle testing should be included for both parents due to their history and impact on the child. Could you address that in relationship to no history of substance use concerns?
Yes, Your Honor. As far as that GAL report goes, that came from 2019. That was an ongoing case. The GAL report made those recommendations because, again, I believe those allegations had been made, and out of an abundance of caution, it is normal for GALs to make those kind of recommendations. As far as I'm aware in reviewing the record, and I could be wrong, but as far as my review of the record goes, I do not see where my client has had to give up any kind of custody or residential time because of a negative UA or a substance abuse issue. It is quite common that when we have one case and it kind of bleeds over into the next case when we are dealing with children, that GALs are going to make different findings and different reports. And sometimes a GAL report is initially going to make a more harsh recommendation out of an abundance of caution. But again, upon reviewing this, and Mr. Lawrence has had time to review it, and we haven't heard from him on the GAL report what his recommendation is, there is still no documented history that Mr. Jensen has provided that has to do with the time that they were together for the allegations that he is currently making when it has to do with Nora.
Thank you. Mr. Lawrence?
Your Honor, I had a chance to review Ms. Day's Guardian ad litem report dealing with Megan Rhodes and Thomas Bailey. And I think that the reason that the GAL recommended potentially a hair follicle exam was due to the fact that Megan did admit to her that she did have, or at least use substances, but that was, she indicated that was like 2 years prior to the investigation of Miss Day. And so there had been an admitted history, but it was like in 2017. And I have not come across anything that would indicate that substances have played a role in any way in interfering with Ms. Rhodes' ability to parent since that time.
Thank you, Mr. Lawrence. Mr. Jensen, your rebuttal.
I mean, like she said, I don't have any evidence, or I haven't submitted any evidence, but she just said that she admitted to having an issue previous. But like you said, it's a slippery road or a slippery slide. So drinking could lead to other things, and you know.
Okay. All right. Thank you. All right. So with regard to the motion, it sounds like in the past there has been some admitted history. Probably it sounds like from 2017. Mr. Jensen indicates that his knowledge of Miss Rhodes is that when she's not paired up with somebody, she tends to party. There's the former test that was done in June of 2024 that was negative for all illicit substances, but it was positive for alcohol. There's an indication that during the pregnancies that she was refrained from using. And so at this point, there's, at least from my view, certainly there's concerns for slipping back into old habits. People that have had substance use issues in the past, they have to be ever vigilant and just on top of things and checking themselves regularly. Otherwise, it can sneak up and overtake one's life. At this point, I think I tend to agree with Ms. Holder. There's no documented SUD issues. While on the one hand, if she were to take another hair follicle test, that kind of really kind of seals the deal, at least for 3 months or 6 months, that, you know, she's again showing that she's refrained from those. On one hand, that may be a real positive, powerful statement for Ms. Holder's client. And on the other hand, it's kind of the power of the state intruding into another person's life without a significant documented history, a recent history of that issue. So at this point, I'm going to refrain and deny the motion. Certainly, if Mr. Jensen becomes aware of any concerns, he can submit a new motion related to any new information that he has. So I'll deny that motion for on today's docket. Any other items, Mr. Jensen? No. All right. Ms. Holder, Mr. Lawrence, anything else?
No, Your Honor.
Okay, so I think we're coming back. We indicated on the 17th or the 11th. We already said it, right?
11th.
The 11th. Okay, we'll be back next week then.
Thank you.
Very good. We'll see everybody then.
Thank you, Your Honor.
Thanks.
Good morning.
All right, good morning. Am I pronouncing your last name correctly?
You are.
Okay, very good. Thank you, Ms. Rooks. Ms. Looney is here representing the state. And can you hear me?
Morning,
Okay? Good morning. All right, and Gareth Clark, are you on the line? Gareth Clark. All right, not hearing a response. Ms. Lawrence, I see that you're here. Can you hear me all right?
Yes, I can. Good morning, Your Honor.
Right, good morning. Very good. So we're here today for a pretrial hearing in preparation for a trial that's set for the week of September 23rd. The readiness hearing is set on the 17th of this month, and that'll give us a clear indication of what day it's going to go out during the week of the 23rd. So just in preparation, Ms. Rooks, have you been in trial before? Have you ever sat in? Or...
I have not.
Okay. Just a couple of things to keep in mind, and I would share this with Mr. Clark also if he was present, and I'll just double check again. Gareth Clark, are you on the line? All right. Mr. Clark, I can't hear you. If you're speaking, make sure you're unmuted. And I'm just looking at the participant list, and it looks like he's not there either. So a couple of things to keep in mind.
About every other one.
Oh, could you repeat that, please?
I'm sorry. He makes about every other court appearance.
Okay. All right. So just a couple of things in preparation for the trial. Often people will want to present some type of documentary proof of either domestic violence or assault, police records, hair follicle testing, mental health reports, SUD reports, class completions, things of that nature. So if anybody's interested in submitting those, you need to get copies of those. Make sure you have a copy for yourself, one for the other side, one for the guardian ad litem, one for the Ms. Looney if it pertains to financial items, and then one for the court. And so make sure you have that. And then also be aware as far as witnesses, please have a specific list of individuals that you'll be calling as witnesses, and then provide somewhat of an estimate of the time that you think it will take to ask the questions of that person and hear their responses. And then kind of line them up in a schedule so you know that, you say, hey, you'll need to be here Monday morning or Tuesday morning. That's when I think you'll be called, and just have that person ready to go. And then also generally, there's opening statements. Opening statements are what a person or an attorney would make in which they outline the evidence they expect will be presented during the trial. So it's just kind of an overview that provides the court with a kind of a preview of what you think will happen or what evidence will be admitted. And then you'd also need to prepare a closing statement. A closing statement is basically from the evidence that's been presented during the trial, why your position should prevail on a variety of issues, whether it's the parenting plan, who gets custody, what the visitation schedule should look like, what the holiday and summer schedule should look like, exchanges, any limitations or concerns for any problems that one of the parents have. So that's just kind of an overview for pretrial purposes in preparation for the trial. Ms. Rooks, do you have any questions about any of that?
I have a couple of questions. The first one being, if my mom wanted to be there, is there a way that she could do it over Zoom since she lives out of town?
Yes, generally the Zoom link would be posted on the court website, and she could simply go to the court website, click on the Zoom box, and then find that particular day's hearing and click on it, and she'd be in a waiting room until she's ready to be called as a witness.
Okay, and then my next question would be, how would I get someone that lives with their dad and has witnessed a lot of things? How would I go about having her testify?
There's two ways to get people to testify. One is to ask them, and they can appear on their own volition. The second is to issue a subpoena, which would be a command from the court. You'd have to submit that to the court for its review, and it would be a command for them to appear for the trial on a particular date and time. So,
Okay, how do I do the subpoena?
so for some resources for that, one, you can check on washingtonlawhelp.org, washingtonlawhelp.org, and look under that. Another option is to contact the CLEAR hotline, the CLEAR, CLEAR hotline. You can speak with an attorney there, and they can give you some direction. Those are probably two of the best resources.
Okay, that's it.
Okay, Ms. Lawrence, do you have anything in preparation for the trial or for the pretrial hearing?
I don't think so.
Okay, thank you. Ms. Looney, anything on your end?
No, Your Honor.
Great, thanks for being here. We'll see everybody then on the readiness hearing on the 17th of September at 1:30 in the afternoon.
1:30. Alrighty.
Thank you.
All right, thank you. Perfect, thanks. All right, Courtney Brummett, are you on the line?
Yes, I'm here.
And remind me of the pronunciation of your last name.
It's Brummett.
Brum, okay, Brummett, thank you. And Mr. Bradley, can you hear me okay?
Yep, I can hear you.
Very good. And Mr. Lawrence, you're on the line?
I am, Your Honor.
Very, very good, thank you. We're here today for a presentation of an order from our last hearing. So let me just pull up those proposed orders. Okay, so so when I looked at this, there's one proposed order on a motion to adjust child support that Mr. Bradley submitted. It doesn't have a lot to it. It's just a 2-page document. Ms. Roman, did you receive a copy of that?
I believe so, yes.
Okay. So refresh my memory. When I looked at this case in preparation for today, my recollection was that there had been no specific ruling on parenting plan provisions, except that I'd made a finding of adequate cause, and that I had not yet made a ruling on child support. But the parties, I believe, had basically agreed to some different orders. Is that where we're at, Mr. Bradley?
Yes. So I had submitted a parenting plan and declaration that Courtney agreed upon.
Okay.
I also reached out to CPS, and I'm just waiting to hear a call back for when that court date is regarding the modification to child support.
Okay, so that parenting plan that you mentioned that you shared with Ms. Brummett, did you submit that to the court?
Yes, I did.
How long ago did you submit it?
It's probably been about a month.
Okay.
So I submitted the original parenting plan before Courtney had agreed to sign off on the parenting plan that I had submitted on.
Okay.
So I didn't know if I needed to submit another one with her signatures or how that worked.
Okay, so I'm looking at there's 2 proposed parenting plans that have been filed, and I'll hear from Ms. Brummett in just a moment. So one is on June 28th. I see, Mr. Bradley, you submitted a proposed parenting plan, and then on July 24th, Ms. Brummett submitted a proposed parenting plan. So of those 2, Ms. Brummett, which one? Apparently, there's some indication that you've agreed to one of those. Is that accurate?
Yes, in the beginning, I was not in agreement with it. That's why I had proposed mine, but we have came to the agreement now that his is what we can go with.
And that's the June 28th submission from Mr. Bradley, that proposed parenting plan?
Correct, the original one.
Okay, and so let me just review that, make sure we're on the same page here. That indicates that there'd be joint decision-making between the parties for school and educational pursuits and non-emergent healthcare, and that the custodial parent would be Mr. Bradley, and there would be that Mr. Bradley's time would be, or your time, Ms. Brummett, would be every week from Sunday at 6 p.m. until Friday at 5 p.m. Is that accurate?
No, that would be Mr. Bradley's schedule. He would have him Sunday to Friday, and then I would have him Friday to Sunday.
Gotcha. Okay. Is that your understanding, Mr. Bradley?
Yes.
Okay. All right. And then the parties made some provisions for spring break and Mother's Day and Father's Day and Thanksgiving and winter break and Christmas and New Year's Day. Okay, so that's all proposed. Ms. Brummett, are you okay with all of those?
Yes.
Okay. And Mr. Lawrence, have you reviewed that proposed parenting plan from June 28th that Mr. Bradley submitted?
I have, Your Honor. There is an issue, not so much with the parenting plan itself, but Mr. Bradley goes into this with the idea that he would like to have Tripp throughout Tripp's middle and high school years. Ms. Brummett is indicating that she only agrees to this on a temporary basis, that when she finds a place of abode and gets a job, that she would like to have Tripp back and go back to the original plan. And so the concern I have is when I met with Mr. Bradley, Tripp was not there. He was at a church camp, and I have an appointment scheduled for this afternoon to meet with him. The question is, if the court accepts the agreed parenting plan, do I need to continue investigating this? And then when Ms. Brummett finds a place of abode and work, then she should file another petition to modify this parenting plan? Or does the court want me to continue in my investigation and try to address the long-term aspects of this? Right now, we are only dealing with the short term. So that is the issue as to whether I should remain involved in this matter or not.
Okay, thank you. In response to that, let me just ask Ms. Brummett, as far as what Mr. Lawrence had indicated, as far as your agreement to the parenting plan, it's for a shorter period of time based on the potential that you may relocate or get a different job.
Yes. I honestly just want what is best for my son at this point. I don't want to prolong any of it more than it needs to be. Like, I just want my son to be stable in a spot and not be bounced around.
And if I understand what you're saying, is that you're in agreement with that proposed parenting plan where you'd have your son on the weekends and dad would have him during the week, and that if you do get a different job or the like, then you would stay with this parenting plan that's been proposed for sake of stability.
Correct.
Okay. Mr. Lawrence, does that change kind of your vantage point or impact it in any way?
Yes, I guess it does. It seems as though this may be a long-term versus a short-term. And so therefore, my role in this is pretty much concluded if the court accepts the parenting plan.
Yeah, I would tend to agree that if you don't have any big concerns about this proposed parenting plan and the parties agree to it, then generally then at that point everybody pulls back and everybody lives with the agreement. Okay. All right. So just to confirm again with Mr. Bradley and Ms. Brummett, the June 28th proposed parenting plan submitted by Mr. Bradley is the one that you're both in agreement to. Is that correct, Mr. Bradley?
Yes.
And Ms. Brummett?
Yes, Your Honor.
Do you have any questions about that? Do you feel like you're being unduly forced or coerced to enter into that parenting plan?
Nope. I'm in agreement with it.
Okay. So I guess what I can do, I have that proposed order. I can print it and I can white out a few things, and just confirming that the parties want that to be basically a final order. So that becomes a final order, and that if there's ever a change that any party wants to make, you'd need to file a motion for adequate cause, meaning that there's enough of a change in that parenting plan or the situation of the child or the parents that it needs to be changed. And that's kind of an initial hurdle that prevents kind of willy-nilly changes of parenting plans. And so you have to overcome that adequate cause, get that secured, and then you could move to potentially changing the parenting plan. Are you aware of that, Ms. Brummett?
Yes.
And Mr. Bradley, you're familiar with that?
Yes.
Okay. So what I will do, I will print off that proposed order, and then I'll go ahead and sign it and indicate that it's a final parenting plan. So I'll just write myself a brief note here. So I'll take care of that today. And then the issue related to child support. There was a motion filed by Mr. Bradley back in end of June where he's asking for change to that child support. So have the parties reached an agreement as to child support?
I mean, my proposed child support modification was just that it went back to 0. We've had, I think, the last 9 years where it was at 0. And then she ended up getting on to TANF, which changed that. So my modification suggestion would just to go back to 0. I don't, like I said in the previous trial, I don't need child support from Miss Brummett, so that would be my suggestion, and that is what I put on the paperwork that I filed with CPS.
Did you file with whom, did you say?
CPS? Is it CPS? Is that what it's called?
No, it's probably the Division of Child Support
That, yeah, that's what it is. Yep.
DCS, I think.
DCS. It was close.
Yeah. All right, Ms. Brummett?
I completely agree with him. I believe he should not have to pay child support, obviously, with Trip being with him and me not paying child support at all. Like, it should have always stayed 0, but like he stated, when I got on TANF, they had to go after somebody.
Gotcha. And is anybody here from the state? I don't know if the state is involved in this or not.
Your Honor, we are not. TANF is not currently active. There is an admin order. It looks like Mr. Bradley's been in contact with DCS about having that modified.
Yep.
Okay. All right. Very good. And so as far as it sounds like with the child support, you've contacted them, DCS. However, let me ask, in this case, I don't believe that a child support order has been entered in this court case. Is that accurate? Or has there been?
I filed a modification paperwork to child support, but I don't know how you guys proceed with that.
And that was filed with DCS.
I did one with the court and DCS.
Yeah, I see your motion you filed on June 28th with the court. And that's where you're asking the court to modify a child support order. And that's why I'm asking, in this case, I don't see that a prior child support order had been entered in this case. And this is a case that was opened up in 2022.
I think that was separate. So when she got on TANF, DCS reached out to both of us, and we had like a separate trial regarding the child support. So I don't know if that indirectly has to do with Cowlitz County. If that makes sense.
Your Honor, may be able to clarify again.
Please.
Yes, what Mr. Bradley is talking about is an administrative hearing. That's where the administrative order was set up. But from what I can tell, there is no previous court order, just the administrative order.
Okay. All right. So it sounds like then if you're asking to change things with the child support, there's no court order. There's an administrative order that's in place through DCS. And if you filed it there, then we'll let them take that motion and run with it. So in this case, there's no order for child support. Therefore, there's no order to change or modify based on your motion. So if you're at the administrative level with DCS, then stay with them. They're kind of parallel tracks. Sometimes you'll have both of them in working in conjunction or in existence at the same time. But here there's only the one, which is the DCS order.
Okay. Yeah, I think originally it did take a few months for them to reach out for an additional court hearing. So it should be a little while.
All right. So Ms. Brummett, do you have any questions about that?
No.
All right. Mr. Lawrence, do you have any comment?
I'm just requesting that the court relieve me of my appointment.
Okay. That seems reasonable. I'll release Mr. Lawrence from his duties in this case, and so he's discharged from the case. Thanks for your service. And then as far as the child support order to adjust it, I'm denying it simply because there's not an order in the civil case to be adjusted, that it's solely within the administrative realm and not here in the judicial realm.
Okay, so I just have to wait for DCS. Is that?
Yeah, you have to work through them and
okay,
whatever processes that they have.
Okay, thank you, Your Honor.
All right, so I'll take just a moment to, I'm just going to deny that order on motion to adjust child support simply because there's not that order in place. So give me just a quick second with that to finalize that, and then we'll take any last minute questions. Okay, so I simply wrote that the motion to adjust child support is denied. No child support order was ever entered in this case. Therefore, there's nothing to adjust. So I wrote that out and signed it.
Okay.
All right. So any final questions from any of the parties?
No, Your Honor. Nope.
Okay.
No, Your Honor.
I'll make sure that that parenting plan gets signed today and it'll be filed. Thanks everybody.
Okay. Thank you, Your Honor.
Right, that'll conclude the hearing. Thanks. I'll ask if Mr. Michael Miller, if you're on the line, please state your name. Michael Miller.
Yes, I'm here, Your Honor.
Okay, welcome to you, Mr. Miller. And Ms. Angel Amasquita, are you on the line? All right, double checking the Zoom call to see if she's on the call. I see that she is on the call. So Ms. Amasquita, are you on the line? Looks like you're still muted. All right, that's one of the extra challenges of Zoom. Sometimes people log onto the Zoom and then go do other things and then they don't attend to the call. So Mr. Miller, do you mind if we just call that in just a bit? I'll take the next case and then I'll come back to it.
Okay, Your Honor.
I appreciate your patience. Thank you. I see Ms. Powers is here representing Ms. Wolski. Ms. Height is here as the guardian ad litem. And I'll ask if Mr. Luciano Torres is on the line.
Yes, I'm here.
Welcome to you, Mr. Torres. Right. I had two items that were appear to be at issue or to discuss today. Well, one is the review of a guardian ad litem payment reimbursement. I have a question about that. And then also is a review to check on the return of the property. Maybe we could first start with you, Ms. Height.
Thank you, Your Honor. I did have an email exchange with Mr. Torres, and we've come to kind of a gentleman's agreement of some payments that have been agreed to, the first of which will be later this month, and then two more in the next 2 months. And he felt like he could manage those. He's had some extra expenses, and it feels like something that's going to work for him and will work for me as well.
Okay, very good. Mr. Torres, do you agree with that rendition?
Yes.
Okay, all right, very good. All right, thank you both for that. I appreciate that. We'll hear from Ms. Powers.
Thank you, Your Honor. The property exchange happened, but there were several items missing. My client went through and told me the items that are most important to her. I apologize that I did not get a declaration filed, and I'd ask for leeway to just go over. There are 7 items that were not returned that are very important to her. There were a lot more than 7 that weren't returned, but these are the 7 that are just very important that she can't live without. So if I could go through those 7 items quick, what I'm hoping is that Mr. Torres and I can set a transfer date for these last 7 items and set one last review hearing to make sure these items are transferred.
Okay, I'll hear from you.
Thank you. The first items on the list are sewing machine. Ms. Wolski had 2 sewing machines in the home. One of them was her own, and one of them belonged to her sister and had been in their family for over 33 years. Her mom had passed it down to her sister, and her sister would like it returned. So we'd like those sewing machines returned. The second item is a picture that was in Mason's bedroom. It's a t-shirt of a Dalmatian that was framed. The Dalmatian t-shirt is very important as it was Miss Wolski's brother Hunter died, and when he died, he had left that Dalmatian shirt to Mason. And so we would like that Dalmatian shirt returned. It has great sentimental value for my client as well as for Mason. Additionally, there's 4 to 5 handmade wooden ornaments that Miss Wolski's grandfather made. He was a woodworker, and he sent those ornaments to her. She had left them in a red Christmas tree bag in the garage. That's where she last saw them. The next items are actually, she has some of her brother Hunter's ashes that she wants returned to her. Those ashes were in a small box on the built-in shelf in the living room, and the ashes are in a necklace shaped as an hourglass inside of a bag in the box. Along with Hunter's ashes, Hunter left her a large pink vase and a banana nut candle. She would also like those returned. And then the last item was her brother Hunter left a white MMA first place competition winning belt to her son Jackson, and it was signed with Hunter's name on the belt. So that would be the last item that she wants returned.
Okay. Thank you. Mr. Torres?
Yes.
Any input on those items that were listed by Ms. Powers?
All of Melissa's items were taken when she picked them up on, I believe it was the 5th of last year.
In my declaration, I made that statement. So the remaining items that I gave her were the items that I believed were mine, but you told me were not. So I don't know what other property you want me to give if I don't have it.
So the ashes of her brother that were in a small box in a necklace, do you know about that?
No, I told you I don't have any of these things that she claims I have.
The vase and the candle from the deceased brother?
No,
Okay, and the belt?
no,
And what about the picture with the t-shirt with the Dalmatian on it?
I do not have any of these items that Amy stated in my possession.
Okay. Do you remember seeing that picture with the t-shirt with the Dalmatian on it?
Yes, I remember she took it when she took all of her stuff. So
Okay.
that's why I don't understand why I'm being accused of having these things when she clearly took them.
All right. And any sewing machines in your home? that
You've
you're-
asked repeatedly and I've already answered it. Yes, I do not have them in my home. I don't have these things in my home.
Okay, that's the first time I've asked you about sewing machines. It's not a repeat question.
Today is the first time you've asked me about sewing machines. The last hearing, you asked me about those sewing machines and I told you I do not have them.
All right. Ms. Powers?
Well, I'm really concerned at this point because my client has consistently been asking for these items. When we had the contempt hearing, Mr. Torres indicated he didn't know what items had been left by Hunter. These are the items, and all 7 of these items are things that are irreplaceable and of emotional value. As you look at the history throughout the case, both in the pleadings and as reflected in the interim GAL report, there's a strong history of domestic violence here. I'm very concerned that all of the very sentimental items are suddenly missing. My client has been diligent in trying to get these items returned and would not have requested them if she had them. A particular concern, of course, are Hunter's ashes, as those, all of these items are things she cannot replace.
All right. So obviously, any items of sentimentality and emotional connection to people who have passed or family members are of great import, and it very well may be, as Ms. Powers describes, it's a continuing flexing of power and control. It may be that, and it may be that Mr. Torres simply does not have them. So the next step that we would look at was a potential search of the home. I'm not going to order that at this time. You kind of hope that better natures would prevail, and maybe they are, maybe they're not. Maybe that power and control is flexing. I'm not sure. So at this point, I don't know what to do unless there's a particular request for action.
The courts just stated they won't do a search of the home. Would it be possible to have law enforcement accompany and not do a search, but just she knows where the items had been and just do a quick walkthrough and see, can we just grab the ashes off the box? In the fireplace off in the living room, I guess I'm not sure what the right remedy is either. But it doesn't feel right to just leave it with nothing here.
So your request would be a civil standby where there'd be a time arranged, law enforcement would arrive with Ms. Wolski. Ms. Wolski would go to those specific locations where she thinks those items are and search for them. And if she finds them, then that she would take them with her.
That would be our request. She's been out of the home since last September, so I don't know the odds that these items are even where they had been when she left in September. So I don't know if that makes a lot of sense. But I hate the idea that these items are potentially just sitting in his home, potentially.
Yeah. Mr. Torres, do you have any comment?
What would be the reason for me keeping these items?
Ms. Powers?
Well, I would say when you look at his actions, what has been his reason to keep any of these items so far? We've had to jump through so many hoops just to get any property returned.
I'll allow Ms. Powers to finish. Go ahead, Ms. Powers.
To get any property returned from Mr. Torres. I don't know why he's kept it all along. But we've had, the court addressed this in November. We've had communications between Ms. Wolski and Mr. Torres's former attorney before she hired me. We had me communicating with Mr. Torres's attorney. We had me bringing another motion. We had the court making an order. We had me and Mr. Torres's other attorney arranging exchange of the property, and Mr. Torres didn't exchange most of the property at that point. We had a contempt motion, and then we had another set where we've exchanged property, and now we've got another review hearing. We've had to go through all of these steps just to get what has been returned, which he had chosen to hold on to since September. So I don't know why he would do this beyond just control, but I believe that he is doing that. And he had told the court previously that he didn't have anything, and yet he turned over several items at our last exchange just a couple weeks ago. So he clearly had those items this whole time period. And if he had those items, why would he not also potentially have these items? Especially because if you look at the list, these are the most sentimental valued items on the entire list that she's requested this entire time. And he's had this complete list since March.
Thanks, Mr. Torres.
So prior to October 18th, 2023, when Melissa was served, my petition for custody parentage, we were discussing co-parenting with both of our kids, Mason and Jackson. Even though Amy says he's not mine, Melissa believed he was mine as well up until October 18th, 2023. So in those discussions, we discussed co-parenting. She tried to get me to pay for her apartment and pay her child support. I wanted to go through the courts, so here we are. In those discussions, she chose to leave the dresser, Mason's dresser, here because we were going to be co-parenting. She chose to leave the air fryer here because we were going to be co-parenting. And she made the choice to leave Jackson's toys. Not all of them. She took some of them, quite a bit actually, some from the back, quite a bit from his room, some from the other rooms as well. But the point is, these were agreed prior to October 18, 2023. So that's why they were here. No discussion was made outside of that. I haven't really had any contact with Melissa since October 18, 2023. The items that are stated that are left here, why would she leave them here if she was abused so badly? Why would she leave them here and continue to be at my house, visiting me, having dinner with the kids, if she had no intention of co-parenting leading up to October 18th, 2023? So my statement is the reason these items were here is because, one, we agreed to keep them here. Melissa agreed up until October 18, 2023, to keep them here to co-parent with me. So that's why Jackson's toys and Mason's dresser were here. The TV was mine up until she decided it wasn't. The air fryer was, as I stated, was left here as the plan originally was to co-parent. So that's why those things are here. And I don't understand why I'm being accused of having items in my home that, what do I need them for? I don't have a purpose for them, right? So why would I keep them?
This case has presented itself with power and control dynamics that are pretty strong and quite noticeable. The rationale that is put forward that for the reason the items have not been returned is that Mr. Torres is continuing to exert power and control over over items which are most clear or most dear and close to a person's heart, items connected to a family member who has passed. That would make a lot of sense for somebody who's trying to exercise power and control. The items that are missing, I don't see any good reason why Ms. Wolski would spend money for an attorney to go after items if she had them in her possession. Mr. Torres may have gotten rid of those items in spite, or he may not have them. I'm not sure. The concerning part is that there's this balance that I'm trying to strike of utilizing the power of the state to search a person's home when hopefully the better natures of humanity would express themselves. And if those items are retained, and maybe, I don't know, Mr. Torres isn't at a point, if he does have them, he's not at a point in his life where he can relinquish those. Hopefully he can in the future, but at this point, I'm not sure exactly if I have much authority other than doing a civil standby, which is problematic because it's been many months since those items were seen in particular locations, and to allow for kind of a wholesale opening up of his home, and would be problematic not only for the time constraints, but for privacy issues. And notwithstanding, I think what is a pretty clear indication of power and control that Mr. Torres is exerting at this point in time, I'm going to refrain from taking any additional action, and just hope that Mr. Torres, if he does have them, that his better nature will come to the forefront at some point.
Okay, thank you.
Okay. That'll conclude the hearing. Thanks. Angel Amasquita, are you on the line? Angel Amasquita. Ms. Amasquita, if you're on the line, please unmute and state your name. Great, still no response. We'll move to the next matter. We'll try again. Sills, are you on the line? Right, not hearing a response. I see Bradley Sills. Can you hear me, Mr. Sills?
Yes, Your Honor.
Okay, welcome to you. And I see Ms. Height is also here. Yep, okay, very good. And it looks like we're on today for a presentation. I have orders that have been presented to me from Mr. Sills. And I have findings and conclusions about a marriage. I have a final divorce decree. I have a proposed parenting plan. I have a child support worksheet and a child support order. And let me just double check one item. Again, let me ask if Maggie Sills, if you're on the line, please state your name. Maggie Sills. All right, no response there. This was a set over from our last hearing where there's just insufficient time for Ms. Sills to review that. And I think with the amount of time that's transpired, there is sufficient time. And then I was just going to double check with Ms. Height regarding the parenting plan and any issues related to relocation.
No issues there, Your Honor. Thank you.
Okay, thank you. And I'm just going to just double check with Mr. Sills. At our last hearing on the 21st of August, there was Ms. Sills was not present at that hearing, and we talked about final orders, and we just needed more time, and now more time has passed, and then there's been no indication from Ms. Sills of any opposition or the like. And I see that there was proof of that Mr. Sills, that you mailed these items to her of today's hearing. You mailed her a notice of today's hearing.
Yes, Your Honor.
Okay. So at this point, I have those proposed orders. Do you want me to go ahead and sign off on those, Mr. Sills?
Yes, please.
Okay. I'll go ahead and take a moment to do that. I've signed each of those documents. Mr. Sills, if you need copies of those, you can check with the clerk's office and they can assist you in getting copies of those. Do you have any questions? Any questions?
No, Your Honor.
Okay, thank you. Ms. Height, any input at this point?
No, thank you, Your Honor.
All right. Thank you both. That'll conclude the hearing. Thank you. Angel Amasquita, are you on the line? Angel Amasquita?
Yeah, I'm here.
Okay. Ms. Amasquita, I've been calling your case a number of times and you weren't present. Were you elsewhere? Ms. Amasquita?
My phone's having some internet problems right now. It's keep cutting in and out.
Okay. All right. I'll ask if Michael Miller, if you're still on the line.
Yeah, I'm here, Your Honor.
All right. Thank you. All right. So at our last hearing, let me just pull up a couple of documents just a moment. At our last hearing, there were some recommendations made from the family court investigator, Ms. Schaefer. The court adopted those recommendations, and as it applies to the parenting plan, Ms. Amasquita drafted a proposed order including most but not all of those items that were recommended. And let me double check to see if if Mr. Miller, if you received a copy of Ms. Amasquita's proposed parenting plan.
Yes, I received a copy, Your Honor.
Okay. And then from your review of things, Mr. Miller, did it include everything that the family court investigator had recommended and that the court had adopted?
Yes, I believe the schedule is going to be pretty much the same for Thursdays, and then the allowed 6 hours for Saturday, I think, is the day she decided she wanted.
Okay. So Ms. Amasquita, looking at that proposed order that you submitted, they have Thursdays and Fridays, 4:30 to 6:30 p.m., and then Saturdays, says some Saturdays up to 6 hours. Is it some Saturdays or every Saturday?
Some Saturdays. It just depends on what's going on.
With your schedule?
Yeah, or his.
Okay. One thing that I didn't note that was included that I think was part of the recommendations of Ms. Schaefer, and Ms. Schaefer's here on the line, she can correct me if I'm amiss, that there was a recommendation of that there be no introduction of significant others or romantic interest until there's been at least 6 months of consecutive dating, and that there was also a requirement of no disparagement of either party or their significant other, and that there was an indication that it was okay to bring the youngest child to the visit. That was not included in the proposed order, and that any visits outside of the Kelso Longview area would need approval by Mr. Miller and 24 hours in advance notice of the same. Ms. Amasquita, did you include those in the proposed order, and maybe I just missed it?
Oh, no, I did not.
Okay.
But, yeah.
Okay. And Ms. Schaefer, anything that did you get a copy of the proposed parenting plan?
No, Your Honor, I did not. I was actually just looking at Odyssey so I could review it, and I can't see it in there either, so no.
Right. So I'll just review it for your edification. There's no 191 factors listed. It shows a limitation on Ms. Amasquita that she's to have limited contact as follows, and it lists Thursdays, Fridays, 4:30 p.m. to 6:30 p.m. and then it states some Saturdays up to 6 hours. It states that it says joint decision making for school and educational pursuits, health, non-emergent health care, and also religion was marked. There's no reasons for limiting to major decision making, that there would be dispute resolution would be go to court, that the custodian is Mr. Miller, and that limited schedule only, the children would live with Mr. Miller and have no contact with the other parent except as described in section 4, which is the Thursday, Friday, and some Saturdays. And so then section 8 is completely blank. Section 9 is blank for summer schedule, holiday schedule is blank because of just those limitations. And then transportation, there'd be pickup and drop off at the courthouse. And then both would be responsible for doing the dropping off. And then that's it. So with that, just that brief review, Ms. Schaefer, any concerns other than those ones that I mentioned of those omissions?
Is there any concerns or recognition that Mr. Chaddock, her significant other, is not to be in the vicinity and that those visitations are supposed to be in the public? Because I mean, that was my general concern, and that was backing up Dad's concerns as well. And that might be a little vague, and that might not be being mentioned.
Right. Yeah. The recommendation was that he not be present or in the vicinity of any visit under any circumstances.
Correct.
Okay. Mr. Miller, any concerns if I were to include that along with the Kelso Longview restriction, no disparagement, and no introduction of romantic interests?
Right. All that sounds fine to me. As long as it's in writing and it's put in the parenting plan, then it sounds fine.
Okay, thanks. Ms. Amasquita, any input on the inclusion of those items?
No, that's fine.
Okay. So what I'll do, I'll include language related to it. It's okay to bring the youngest child to the visitation by mother, and that any visits outside of Kelso and Longview need to have approval by the father, and it has to be given at least in 24 hours advance notice, and that Mr. Chaddock shall not be present or in the vicinity of any visit under any circumstances, and that no significant others or romantic interest would be introduced to the children until 6 months of consecutive dating, and that there shall be no disparagement of either party or their significant other. So I'll include that in the parenting plan and then sign off on it. And is it so any questions about that? Okay.
No.
Your Honor, can we just clarify that Angel has 2 younger children, not just 1 younger child, so she can bring both younger children?
Great correction. Thank you.
Thank you.
Youngest children. Yep, I'll do that. So I'll go ahead and sign off on that. And if either party needs a copy of it, you can check with the clerk's office and get a copy for your records. Any final items from any of the parties?
No, Your Honor.
No.
All right, very good. I'll make those changes and pardon me, those additions, and we'll file that today. Thanks everybody for your assistance.
Thank you.
Okay, thank you.
Yes, 08, we have Ms. Janice Cuevas is present, and we have Mr. Humberto Cuevas present. Mr. Cuevas, after our last hearing, I asked my assistant to send you a letter to let you know of interpretation services, so that if you wanted an interpreter to interpret everything. I think you speak great English. I think you understand most everything. Sometimes the language in court is it's less common. And so that if you wanted to have an interpreter, I'd let you know that there's interpretive services
I
available.
would like to have one.
Okay.
Can I tell you, please? I already went through 5 different lawyers, attorneys, and they don't have the time to book me. They told me the closest one is around the 17th to the 20th. So I don't know what else to do. I went across from the last one I see. It is Evergreen Legal Service and I went and checked yesterday. I filled out the paperwork. They told me they don't do nothing until next week. So I don't know what else to do.
Okay. So yeah, recognizing that it's tough to quickly get in to see an attorney. I recognize that. I hear that often. As far as the interpreter, it sounds like you would like to have an interpreter. Is that correct?
Yes.
Okay. Madam Clerk, maybe if you know, and if you don't know, that's fine. Scheduling those is done through court administration. And so Mr. Cuevas would just need to contact them and schedule that.
Yes.
Yeah, that'd be great. So Mr. Cuevas, the clerk is kindly going to write down the email address of court administration. So you'll need to use that email address, or you can call and ask them to set up an interpreter for the next hearing.
Okay.
So they will do that. The interpreter would join us via Zoom and be present and assist with that. So we're here today for a motion for spousal support. But let me back up. Mr. Humberto, did you receive that letter from the court about the availability?
No, I haven't seen it. I've been working really late from 3 in the morning to 6, 7 in the evening.
Okay.
So I haven't checked my mail this past few days.
Okay. The letter, let me just see if there's a listing of when it was sent. Our last hearing was on August 21st. I think it was shortly thereafter that I decided in an abundance of caution. And I recognize Ms. Cuevas may have her own ideas about the necessity of an interpreter. I think from kind of a judicial standpoint, it's always better to err on the side of caution. I've lived in a different country that speaks a different language, and I think I speak pretty well, and I think I understand pretty well. But there's certain topics and areas that I'm not super fluent with, and so that's why I'm erring on the side of caution. So I know we're scheduled here to talk about the spousal support on Ms. Cuevas's motion regarding spousal support. What I'd like to do is, I recognize finding an attorney is difficult. I'm not going to unduly delay this. I think we're going to schedule this, and Mr. Humberto will find an attorney, or he won't have an attorney, but we will have an interpreter present for that hearing. So what I'm suggesting is, it doesn't take long to get an interpreter lined up. We could probably have one by next week. And I recognize that it's time away from your schedules doing things, but I'll just ask if you're available next week on September 11th, Ms. Cuevas. That's a week from today, the 11th.
Yes.
Okay, Mr. Cuevas, are you available next week on the 11th?
Yeah. Yes. This week I'll be in Oregon. Next week I'll be on Fort Washington. I think I can come.
Okay.
I can come to court.
Okay, and so you'd be available to either be here in court or join us via Zoom?
Yes.
Okay. So what I'll do, I'll take it upon myself to ask court administration to arrange for an interpreter for next week. So the interpreter will be here, and then we'll take.
I don't have to call them.
You don't have to this time. Yeah. Going forward, if we have next week, if we schedule additional hearings, then you would have to contact court administration and arrange for the interpreter.
Okay, thank you.
All right. Ms. Cuevas, any questions or comments at this point?
Oh, I have a lot.
Oh, I know. I see it in your face. Okay. Okay. We'll come back next week, and we'll take up the motion for spousal support next week.
Okay.
Okay.
9 a.m.
9 a.m. And just be aware that the motion's been filed, and Mr. Cuevas, have you submitted anything in response?
No, I give all the paperwork that I fill out to everything. And they tell them they can do nothing until next week, and they talk to them not building.
Okay. So just so you know, that if you want your position, if you want me to know what you want me to know, you have to write it down. in a declaration, file it with the court, and send a copy to Ms. Cuevas.
Okay.
Otherwise, when we come to court next week, you'll be severely limited in what you'll be able to share. So you need to put something in writing on paper and then submit it to the court and also to Ms. Cuevas.
The reason I submitted to everyone because I write it all in Spanish and they're gonna translate it in English. They're gonna help me out to a translation and write it in English.
Okay.
So I did everything in Spanish. And
So
they
that's-
told me they can do the translation and
Is that Evergreen Interpretive Services or Evergreen Law Firm?
law firm.
Okay. So that just needs to be completed probably by no later than tomorrow or the next day, and it has to be submitted to the court either tomorrow or the next day, so it hits my file.
Okay.
So at latest tomorrow, it has to be filed.
Okay.
And if they can't help you get it interpreted, you can check with the Ethnic Support Center here locally, the Ethnic Support Center. They do a lot of interpretation from English to Spanish and documents, and they can help you with that.
Ethics of Support Center.
I think, well, it's Ethnic Support Council.
Council.
So if you just look that up, they're located in Kelso, just by the bridge.
Okay. I'll go for it.
So we'll be back next week.
Okay.
Thanks.
Thank you.
We are here this morning on Ms. Cuevas's motion for spousal support. There's some questions I have for Ms. Cuevas I just need to clarify. You mentioned the sale of your mother's home.
Correct.
Correcto.
When did that occur?
It happened in 2018. I think it was May or June.
And were you the owner of the home or was your mother the owner of the home?
My mother passed away and I inherited the home.
So that was your separate property. It was not the property of both you and Mr. Cuevas.
Correct.
Thank you. And then you mentioned that Mr. Cuevas has a house in Mexico.
Yes.
When was that home acquired?
He purchased that home before we were married.
Thank you. In your tax records that you submitted, there was a indication that your most recent tax return was about $30,000. Does that amount include your federal service pension?
No.
No.
What is the monthly amount of your pension?
I'm not receiving one. I have the 10.
Your Honor, the interpreter gets some time to do his work. Thank you.
Yeah, I'll ask Ms. Cuevas just to wait for the interpretation and then proceed. So, are you receiving, what's the amount of the pension that you're receiving monthly?
Zero.
And what's your plans with regard to those pension monies?
I am unable to receive it until after I turn 60.
What's your current age?
¿Cuál es su edad actual? 56.
Okay. And is there an estimated monthly payout once you turn 60, if you do, in fact, withdraw funds then?
I have no idea how much it will be. I only was working part-time and most of my wages went towards health insurance premiums.
Thank you. And then your current income is about $2,000 a month as a caregiver?
Correct.
That's all the questions I had for you at this point. With regard to your argument for spousal support, you're indicating you're requesting $1,000 per month.
Yes.
Sí.
Do you have additional argument you'd like to provide, or?
Can you repeat that, please?
Any additional argument or statements about why that $1,000 per month spousal support is appropriate?
I'm currently in a position to where my cards aren't being paid. And since April, I have inquired. I've been in the hospital 4 times and have hospital bills as well.
Do you have an estimate of what the hospital bills currently stand at?
$1,000.
$1,000.
And I'd like to add that the life insurance premiums went up to $345 per month.
That's for both?
Correct.
Para ambos. Correcto.
Is that term life insurance or whole life insurance?
It's term life insurance, and just this last month, it rolled over off the 20 year. And so now it's increasing.
Because you're older.
Yes.
What was it the premium cost prior to the increase?
Mine increased a couple years ago, and his just recently went off last month. So it was $243 last year, and now it's $345. Initially, for the first 20 years, the premium was $185.
Thanks. Are there any additional points in support of your motion?
I think that would be it.
Creo que sería todo.
Thank you.
Gracias.
Mr. Cuevas, I want to ask you a few questions before you share kind of what you want to share this morning.
Very good.
In a prior order, I ordered that you pay the mortgage, taxes, insurance, and utilities for the house.
Permítame. I've been falling behind because I don't have money. I was paying. I just finished paying the hospital bill when I had a fall a couple of years ago when I had to take out a loan for $18,000. And I borrowed the money from the company that I was working for, and I was paying them $1,000 a month to be able to pay that off.
Apenas recibí mi primer cheque, este cheque pasado de.
Just about a few days ago, I got my first check, my full check, after I was able to pay off that amount to the company.
So my specific question is, what's the total of the mortgage, taxes, insurance, and utilities?
That's $1,200 for mortgage, and also $650 every 6 months for car insurance, and the mortgage includes the home insurance.
Y $100 de las aguas negras, y pues el seguro del agua varía.
$100 for sewage, and the water variates.
Yo tengo mi hijo de 12 años, y mi novia vive conmigo, y mi hijo tiene déficit de atención, so tiene que estarlo cuidando todo el tiempo, ella no puede trabajar porque tiene que cuidar al niño.
I have my son, my 12-year-old son, and my girlfriend has to take care of him because he has ADHD, and she has to take care of him the whole time. That's why she's not able to work.
Él no lo permiten irse en el autobús de la escuela, tienen que llevarlo y traerlo.
He is not allowed to ride the school bus. He has to be taken and brought back.
Okay. My next question is, what's your gross and net monthly income?
3,652 gross income.
What were you just looking at?
¿Qué es lo que estaba viendo?
Un talón del cheque.
A pay stub.
Will you please pass that to Ms. Cuevas, and then once she's done looking at it, then maybe she could pass it up to me. And are you paid by salary or by hour?
Salary.
How much do you get a year? What's your salary?
¿Cuál es su salario anual?
Como 92,000.
Around 92,000.
Okay, so that 33,652, that's paid every 2 weeks.
Sí, correcto.
That is correct.
And did you submit any documents to the court that you wanted me to look at? Did you file anything?
Estoy muy enfermo.
No, because I was very sick. Since the last court hearing, when I was here, I was feeling like I was going to pass out. I've had diabetes for 5 years and
25
years, and I also have problems with my right lung, and I also injured two of my discs when I had the fall.
Did you miss any work due to your illness?
Sí, perdí 3 meses.
Yes, I missed 3 months.
Y yo pago,
3 months or 3 days?
3 meses o 3 días?
3 meses.
3 months.
Yo pago la aseguranza.
Which months were those?
No tengo aseguranza médica yo.
Which months were those?
¿Qué meses fue los que perdió de trabajar?
Fue el año pasado, fue septiembre, no, el año antepasado, hace 2 años, septiembre, octubre y noviembre.
That was the year before last, from September, October, and November.
So that's 2022, correct?
Sí.
Yes.
Y yo no tengo aseguranza médica y el accidente no fue en el trabajo.
And I have no medical insurance, and the accident didn't happen at work. That's why I've been having to pay out of my pocket for all of my medications, including the diabetes medication.
And how much does that cost per month?
Mine, the thing is that I buy them in Mexico, because since I don't have a prescription, they won't sell them to me here.
So how much per month?
Pero cuánto por mes?
Traigo medicina para 3 o 4 meses y me sale como en de $2,000 a $2,500.
I bring medicine for 3 or 4 months, and I pay from $2,000 to $2,500.
Okay. Any additional information you'd like me to consider in relation to Ms. Cuevas's motion for spousal support?
You know, our marriage was broken since a long, long time ago. She left the house with her boyfriend back in 2011, 2012. And about a year or 2 later, she came back and asked me for permission to stay at the house because the place where she was living in, they didn't have any power. And I allowed her to go back. Later on, she was constantly telling me, buy me out. And she was saying, just give me $50,000. And so we refinanced the house to be able to give her the $50,000 because she said that she would sign divorce papers if I gave her the $50,000. when I gave her the money later on, she refused to sign the documents. She just left, and she didn't want to sign the documents, the divorce documents anymore. And in 2010, she did the same thing. She asked me to refinance the house to be able to pay off her credit cards. She does this to me every 5 or 6 years.
I see.
Had a US bank account, and when I would see the mail, I would realize that she would spend about 2 or 3 days at the casino. There's where she spends all of the money, the casino. And every time she calls me to ask for money. And I said, I don't have any money. I don't know where you're getting that information from, but I have no money. The house in Mexico, my father put the house under our names in 2012 for all of us, for all of my siblings. We are 3 brothers and 3 sisters, and I don't have the deed. My sister has the documents.
And you were married, you and Ms. Cuevas were married in 1989, is that correct?
Yes.
And it sounds like you've had periods of separation. When was the last time you were together and last time you were separated?
In 2018, she left the house when I gave her the money, and she left her belongings there. And I asked her to go back and retrieve them. When she's saying that I wouldn't allow her to go in there, that's a lie. I asked her to bring a truck and retrieve all of her belongings. When I had to go to Mexico, the downstairs bedroom flooded, and the house was vacant for 3 months. And when I came back, I had to get rid of everything, throw it in the garbage.
So I just need to help focus a little bit. When was the last time you separated, and how long, and when was that?
2018.
And from 2018 until today, or sometime this year, you've been continuing to pay the mortgage?
I paid it on my own the entire time.
Okay. Even though you're separated?
Aún que estén separados.
Todo el tiempo lo he pagado yo solo.
Okay.
I paid it myself the whole time.
Yo no sabía que yo tenía aseguranza de vida. Yo no me recuerdo que tenía. Yo no sabía de dónde dice que la tenía.
I didn't know. I was unaware that I had a life insurance. So I don't know where she's getting that from.
Okay. Thank you. Mr. Cuevas, I'm not sure if you have additional information. My focus here today is whether that spousal support is appropriate. So anything you want to share about that specific issue, I'll give you just a couple more minutes to share.
I also have to pay for my son's medical bills. They cannot help me because of the amount that I make.
How much are your son's medical bills?
¿Cuántas son las facturas médicas de su hijo?
Ahorita debo 1,200 to child adolescent clinic.
¿Dónde, perdón?
En la clínica de niños y adolescentes.
Right now, I owe like 1,200 at the children and youth clinic.
Okay. All right. Thank you.
Gracias.
So what I see here is that the parties have been married since 1989. There's allegations of infidelity on both parts, that there's been periods of separation during their marriage, that Ms. Cuevas currently works as a caregiver and does not have access to her pension at this point. And Mr. Cuevas earns about $7,300 per month, or $92,000 a year. The indication is that Mr. Cuevas has been the principal breadwinner over the course of the marriage. Both parties have their health concerns. Ms. Cuevas suffers from serious heart issues, and Mr. Cuevas suffers from diabetes, amongst other concerns.
Yeah.
So the court looks at kind of the standard of living that the parties enjoyed while married, any potential time that would it take for one party to gain additional information or training or education so they can earn a better income. So the court looks at those things, and I'm going to grant Ms. Cuevas's motion for the $1,000 per month of spousal support.
Entonces, el tribunal ve estas cosas y por lo tanto se le va a conceder a la señora Cuevas su moción para la pensión marital de $1,000 por mes.
This motion has been pending since July 2nd. As a result, the spousal support requirement will begin on August 1 and the first of each month thereafter.
Del mes.
Ms. Cuevas will be continue to be responsible for the life insurance payment for both she and Mr. Humberto. In the prior order, that requires Mr. Cuevas to continue to pay the mortgage, and the mortgage-related expenses continues. Ms. Cuevas, do you have any questions?
¿Tiene alguna pregunta, señora Cuevas?
No, Your Honor.
No, señoría.
Mr. Go ahead.
Yes. How would that be paid? Is it paid to the court, or is it paid to me, or direct deposit?
¿O va a ser depósito directo?
Do you have a preference?
¿Tiene alguna preferencia?
No.
Okay. Mr. Cuevas, do you have any questions?
Sí, va a causar un gran estrés en mi familia. Voy a perder la casa. Yo no he hecho los impuestos por 3 años porque no tengo dinero para pagarlos. La casa, tengo 3 años que no pago los impuestos de propiedad. Voy a perder la casa. Yo no puedo trabajar más que 3 o 4 años. Es todo lo que voy a trabajar. Ya no puedo caminar.
Okay. Tiene que darle tiempo al intérprete, por favor.
Sí.
Yes, this is going to cause a great stress. I haven't been able to pay for the house for 3 years because I don't have money to pay for the house. I haven't been able to pay the property taxes and I'm going to lose the house.
Do you have any questions? It was my question to you. Do you have any questions about the court's order?
Mi pregunta simplemente es, ¿tiene alguna pregunta para el tribunal respecto a la orden?
No tengo ninguna pregunta, solamente que no tengo dinero para pagarlo.
No, I don't have any questions. I just don't have the money to pay it.
Okay, all right. One moment, please. One last item is that the spousal support obligation shall continue until Ms. Cuevas reaches age 60, at which time both parties can ask the court to review the matter. So I'll review the order so everybody's clear on it. Mr. Cuevas shall pay $1,000 per month of spousal support on the first day of each month, starting August 1 of 2024. Pardon. Ms. Cuevas will have possession of the Subaru, and Mr. Cuevas shall have possession of the Honda. Mr. Cuevas will continue to be in charge of paying the mortgage, utilities, homeowners insurance, and property taxes.
That's it.
Ms. Cuevas will pay the life insurance premiums, and the support obligation will continue to age 60, at which time it can be reviewed by either party. So that's the court's order, and that concludes the hearing today. Thank you.
Esta es la orden judicial y con esto damos por terminada la audiencia. Gracias.
Thank you, Mr. Rojas.
You're very welcome, Your Honor.
Thank you, Your Honor.
All right, the parties are coming forward. I see. Do you pronounce your last name? Is it Malave? Malave. Malave. Long A. Okay, very good. That's easier. So Ms. Malave is here and Mr. Aguayo is present. You're Mr. Aguayo? Yes. All right, very good. All right, we're here on a motion brought by Ms. Malave related to a restraining order. Looks like there was service. So and I'll confirm this with Mr. Aguayo. Just confirming that you received a copy of the temporary restraining order and a notice for today. You got that?
Correct.
And then did you receive any other documents?
Yes.
What else did you get?
Parenting plan.
Got a proposed parenting
plan about 2 days ago.
Proposed parenting plan. Okay. All right. Very good. And then let me just double check. So this was served. It looks like you received the documents on the 27th of August.
Correct.
That was last Tuesday. And then did you file anything in response?
No.
Okay. Were you planning on writing something down and submitting it to the court?
Yes, I plan to do that after I leave here today.
Okay. Okay. So generally in these instances, I'd like to hear from both parties in written form. So I know what Ms. Malave has to say about the matter. I don't know what you have to say in the matter. So that's why I will ask you if you're going to write something down. So if you are going to write something down, I'm fine continuing the matter and also continuing the temporary order for a week or so to allow you time to write it out, submit it to the court, and submit a copy to Ms. Malave. That would allow for your voice to be heard. Then when we'd come back, I will have read what she has to say, Ms. Malave, what you have to say, and what you have to say, Mr. Goyle. I'll have read it, been able to compare and contrast, and then we'd come here and then you'd kind of just make your argument here in court. Okay, so let's take a look at scheduling. Today is the 4th of September. I'm not sure what your timeframes are, Mr. Aguayo. As a general rule, when rescheduling these types of hearings, I generally schedule them out 2 weeks. So it'd be to the 18th of September. Any concerns if we were to set it out that far, Ms. Malave? Okay, Mr. Aguayo?
I have another court date on the 18th.
Okay. Do you know what time the court date is at?
2 o'clock, I believe.
2 in the afternoon?
Yes.
Okay. So it would be on the, on the 18th, it would be 9 o'clock in the morning for here. So we should avoid any conflicts.
That should be.
All right. So what I'm going to do is that we'll continue the matter to the 18th of September at 9 o'clock in the morning. I'm also continuing that temporary restraining order that was ordered back on August 15th. So that order is still in effect, and then we'll just address it when we come back on the 18th. So I'll take a moment just to write that into an order, and then I'll field any questions that either of you may have. Okay, so I signed off on the extension of the immediate restraining order, and so that the August 15th order is still in effect, and then we'll come back on September 18th. September 18th at 9 o'clock in the morning for the hearing on whether that order continues or whether it ends. Any questions on your end, Ms. Malave?
Till the new temporary order is filed so I can get a copy.
It's a good question. Did you say that because I heard Mr. Aguayo, you said that you got a copy of a parenting plan?
Correct. I just got one.
You submitted it.
No, I didn't submit it. She submitted it.
You submitted it.
Yeah.
I got a little confused. So tell me your question again.
The continuous restraining order. When will that be ready to pick up for a copy at the clerk's office?
Oh, this one. You can probably pick it up. I'm looking at the clerk because she's the one that kind of controls that.
If you're willing to wait.
Yeah, we are.
You could come purchase a copy right now.
Okay.
So if you just wait a few moments, I will have one on the front counter. Okay. Get your attention. If you just sit on that bench right in front.
Okay.
If you'd like to come purchase a copy right now.
Okay.
Any other questions, Ms. Malave? Okay, Mr. Goyo, any questions?
Nope.
Okay. All right, that'll conclude the hearing. Ms. Malave, if you want to Let's actually, why don't we have Mr. Guile, since that restraining order is in place, would you mind just exiting first and then?
You kicking me out?
Say again?
Are you kicking me out?
No,
I'm just kidding.
I'm giving you the option to leave now so that there's no
I appreciate
questions
it.
about the restraining order and any potential violation of the same.
That's fair. I appreciate it.
Thank you.
Have a good-
All right, so I'll just we'll hold tight here. And I'll just double check, Ms. Malavi, if you want a police officer to come up and escort you to the clerks and out, I'm happy to call one up. I'm happy to if you want. If you change your mind, let us know. Today, but has not yet been heard. Yeah. Tell me your name. Okay, so Mr. Salazar, let's double check on that. I reviewed your case earlier in anticipation it'd be on today, but there was the clerk has more information on that.
There was an order shortening time to the attorney docket yesterday. The matter was heard on the attorney docket at 9 a.m. yesterday. The judge at that hearing struck the matters for today as she heard it yesterday.
I'm sorry, say that one more time.
The matter was set to yesterday per an order from the petitioner's attorney. There was an order shortening time signed by the court on the 29th. So it was Thursday. The matter was set to Tuesday at 9 a.m.
Right, so.
And the matter was heard yesterday at 9 a.m. And the judge who heard the matter struck today's hearings as she addressed the matters yesterday at 9 a.m.
So on the 28th, I came in to do a motion for our son because the last hearing we had, our son was supposed to go to Castle Rock.
Right.
He didn't get into Castle Rock.
Right.
So we were supposed to come back to court.
Right.
So on the 28th, I said, can we do a quick shorten for the 4th? A month ago, I already did one for today for our child support. So we were already going to be here for child support. And then last week I did the motion for the school to try to figure that out.
Yes.
Then on the 29th, she did one to vacate. But on the 29th, I called the clerk's office and they said, no, you're still good for the 4th.
Except the other attorney did an order to shorten time to yesterday
And that
and
was
had
fine.
her matter heard yesterday. And the judge who heard it yesterday struck today's hearings. So a judicial order struck your hearing for today.
So I called, and so the thing is I received that on the 29th by email that they were trying to do that for yesterday. But when I called the clerk's office, they said that.
It would have still been set. The matter was today's hearings were struck by a judicial officer yesterday at like noon, when your case was heard yesterday. Because the other attorney did an order shortening time on Thursday. She shortened time to yesterday, set the matter on for yesterday and had it heard.
So that means just everything that we already had scheduled for today just goes away.
Right.
And when I called the clerk and they said we were still good for today.
Yeah.
It would have still been set unless you called afternoon yesterday. So the matter was heard yesterday morning on the docket.
Are there any further dates that have been set? And any notes from the docket? Because Mr. Salazar, I take notes in preparation for all the cases. And so I had taken notes yesterday and then I prepped for the case and then I looked later in the day and then it was gone from my file that I have up here and it was removed and I'm like, what happened? And then I looked back and then it looked like there was the other side, they filed a motion to shorten time, which put it on yesterday's docket. Apparently you didn't get notice of that or didn't know about that. The case was heard, there was some type of outcome. They struck today's hearing. And so, yeah, I'm sorry all that happened without your input, but so what you'll need to do is just double check to see what happened at that hearing. And then if you feel like you were aggrieved in some manner, since your voice wasn't heard, then you'd bring that before the court and say, hey, I didn't know about this or whatever was happening, and then ask for whatever relief you think is appropriate. So the clerk here do we have some of the minutes?
It says an order was signed. I don't know what order because it's not entered into the case yet, Your Honor, but it says a court signs order. It looks like potentially to vacate the temporary parenting plan that was previously ordered.
Okay.
You'll have to, once it's entered, probably look at it. But as of right now, I can see that an order was signed. It looks like they discussed that it was going to be to vacate the temporary parenting plan. And then they struck the hearings set by you for today.
And one other option, besides getting a copy of that, is you could call Ms. Bliss. Apparently she was the attorney that brought the motion. And you could ask her, it's as if one attorney calling another attorney since you're representing yourself and you're free to call and ask her what she knows or what happened. And you can also check with the clerk's office for a copy of the order.
And I don't know if it was like, it says court signed order, so if you imagine there was an order presented at hearing or she did a bench order.
Right.
But it's just not in the case yet.
Okay. So that's what we know. So I guess at this point, those are your options, is to, one, get a copy of any orders that happened. You can actually check with court administration too and get a copy of any of the video to see what actually happened, what was said. That's another option. Then you can call Ms. Bliss and get any information from her. And then from there, you could, if you feel like you've been aggrieved in some way and that your voice wasn't heard, then you could file a motion and have the court address it. So apologize all that happened. Okay. All right. Thanks.
I'm not good with any names, so no disrespect intended.
None taken.
Okay, thank you. Okay, so we're on this one. We've got essentially you filed a petition for a parenting plan and you requested a restraining order. Temporary looks like was granted. And then it was put over to today. And did you file any kind of response, sir?
I did to the restraining order.
I'm sorry?
To the restraining order, yes.
Okay, I have a declaration. Okay, I do have that one. That was one I read. Okay, got it. Okay. And did you receive a copy of that, ma'am? Okay, that is problematic. So we probably need to have you have a copy of that before we do anything. So I could keep putting this off. Could she go to the clerk's office and just get a copy of that right now while we're his response? Did you have a copy of your response? Okay. Okay, because she needs a copy of that. I don't see Kelly on here. It's going to have her do one. Yeah, if you could have her jump on real quick. I'm going to have my staff print a copy of that, and I'll have you take a look at that, and then we'll come back and do this. We've got one other case, but I want you to see that before we move on. Lave and Aguayo. I think I got that a little better. Did we get you a copy, ma'am? Okay, very good. I thought I saw her come in while I was otherwise focused there. All right, and I did review that declaration. So, ma'am, this was your motion, and it looks like it was set over from last week, 2 weeks ago by Judge Evans to get a response, which you now have. So let me hear what you have to say.
For his drug use, it's been worse now, come to my attention, and I worry about Medallia, our child's safety.
Let me just check something here, because when I read your motion, you have anything to say about that, sir?
Yes, I do. When she decided that she was going to keep our daughter from us, I offered her a drug test, a piss test, and she ignored me. And I never got a response after that. And I offered her multiple times. I told her that I would take it to her and I would do it in front of her, and she just continued to ignore me. So I don't understand. I could take a drug test right now. I don't understand why she'd come in with that, I never denied her one time that I would take a drug test to prove that,
Okay. This case has not gotten to a point of getting a guardian ad litem appointed, have we? Just looking here. And other than the declaration you filed, you've not filed an actual response to the petition. Is that right? Okay. So it looks like this is just looking at the case. Again, I'm kind of covering this docket. So it was filed as a petition for a parenting plan. And you requested that, ma'am, excuse me. Look at my pleadings incorrectly here. And so if you look through that, there's a proposed parenting plan that you should have gotten at some point. Did you receive that document?
What was that? Can you repeat it?
A proposed parenting plan that she filed?
Yes.
Okay, so you got that. And do you agree with that or disagree with that?
No, I'm going to turn in my half.
Okay. So you're going to need to file a response to that. And at this point, the issue really before me today is what do we do as far as a restraining order? It's not about setting up a parenting plan or anything else. When I read through your documents, ma'am, and your response, are you from Cowles County, or are you from California, or?
No, I'm from Chicago.
From Chicago,
Yes.
Okay. But you're living here now?
Yes, I've been here for the last 12 years.
Okay. So really the big issue that I would see that's been raised is whether or not the child stays there, at least until we get this thing sorted out. And you don't want the child to leave, obviously. And you're planning on staying here? Okay. And so do you have any objection to that? There'd be some restriction that neither of you could remove the child residence from Cowles County? You're okay with that? So let me take a look here, see what I've got. I better just take a quick look here at one thing before I move forward. When I look at your motion, ma'am, and this is not any comment other than there's a kind of a threshold to meet for a protection order. There's not really much of a threshold to meet to restrict either of you from moving with a child or anything like that. It seems to me, based on what's in your declaration, there may be some history. You're concerned about it and using drugs. And it would seem that an order that restrains him from actually both of you from removing the residence and him from using any substances around the child, that probably addresses the issues that you've raised here until we can get a little farther on the case.
We did have an incident the day he was served with the restraining order,
Mhm.
because I had our child at soccer practice and he must have followed me there or something, and he took her while she was playing from the park and then drove off with her. And that's how he got served with a restraining order, because the cops had not served him yet.
Is that accurate, sir?
Yeah, but I never got charged with anything, and I did nothing wrong that day.
Was that before or
I
after?
hadn't got served. And then I had my kid and I got served in front of my kid. And then the cops came and grabbed her and then they gave her to mom. She's under the impression that I kidnapped my own kid, which is false.
It looks like the Castle Rock police indicate when did you say this happened as far as the soccer thing?
The 27th of August.
Okay. So if I'm reading this correctly, that sometime that day is the same day he got served the paper.
Because the officer said that if I could find him with our child, he can get served. He got served and the cops failed to read the restraining order and left her with him. And then we found him again in Kelso, so we were able to get her back.
Okay. All right. So there was no restriction in place that he was aware of at the time.
Yeah,
He took. Okay. Okay. Well, that kind of clarifies things a bit. Obviously, we can't have the two of you taken off with the child without the other's understanding and agreement, either direction. And we don't have a temporary parenting plan at this point. And I haven't seen what your response to that's going to be. There is a paternity order someplace, or is there not? Is this
It's on the birth certificate and we
Okay.
filed the affidavit stating
Okay.
that he's the father.
Okay. Okay, so here's what I'm going to do. I'm going to sign a different order. What I'm going to do is I'm going to set this out a couple of weeks. And so I'm going to need to have you file your proposal on a parenting plan.
Okay.
And then we're going to come back in a couple of weeks. And depending on what those two look like, we may appoint a guardian ad litem. I don't have a motion for temporary parenting plan at this point.
With the restraining order.
Um,
And that's what he was served with. But it never got looked
I just
at.
have well, okay, wait a second here. Hold it. Motion for,
I don't think it was ever acknowledged because he didn't have time to respond, so the judge just set it over 2 weeks.
okay. So that was, okay, I see what that is. Did he? So he was served that, it looks like, on 9/1. So that, if he was served that on the 1st of September, then we probably need to go over at least another week on that anyway, just for time of service for that. And it looks like what happened is on the 28th, all that the officer served was the restraining order.
Yeah, they said that they were unable to serve him the parenting plan, even though I had a copy of it.
Okay. Well, that was served, it looks like, on September 1st, which would be short service for today. So I can put this on for next week. Right, but the motion for immediate restraining order includes an adopt parenting plan language in it towards the end. That's what I was looking for. If you look to paragraph 14 on page 5. Right, so that, and he just needs to have, under our court rules, he's supposed to have 21 days notice to do that. So, do you want to come back next week or do you want to come back in 2? I'm going to put a restraint that says that you're not going to have any specific contact with the child between now and when we come back. So I put it over for next week. But you need to file your parenting plan and your response to this probably today or tomorrow, and a copy to her. In the meantime, I'm going to indicate here.
Hello?
Just 1 minute, sir. All right. So what I'm going to do here is that neither of you are to remove the residence of the child out of Cowlitz County pending for the court order. You, sir, are not to use any non-prescribed substances immediately prior to or whenever you're around the minor child. A child is going to reside with mom, and you'll only have contact until we have another hearing as agreed between the two of you. So if she says you can see the child or whatever conditions that is, that's what we're going to follow. I'm not making any rulings on anything else. I'm just simply saying you don't get to see the child unless she agrees to it under whatever those conditions are between now and next Wednesday. So that means you don't go pick up the child, you don't anything else. And I want to make sure we don't get anybody in trouble. Then we'll take a look at the parenting plan next Wednesday at 9 a.m. I need to have you file your response and parenting plan, hopefully today, no later than tomorrow. Get a copy to her. Okay. So there's that, or you can get a copy of this order. I'm not sure how good that'll come through, but that'll give you a copy of that.
Malave, okay, Malave. Ms. Malave is present in the courtroom. I'll ask if Jorge Aguayo is present. Very good. Come on up, Mr. Aguayo. Feel free to take a seat.
We're going to take it.
Just right there in front of the microphone that allows for the capture of your voice and to be on the recording properly. All right. So this is Ms. Malave's motion for a temporary parenting plan and restraining order. And it looks like the parties had been here at previous hearings. And so let's double check here. So Judge Basher heard this case, I think it was last week, and kind of gave just an interim order to set us over to today, where he indicated that there's a restriction on any of the parties removing the child from the state, that Mr. Aguayo was prohibited from using any illicit substances either before or during the visits, and that the visits would be as agreed between the parties. So that's that brings us to today. And I have reviewed a proposed parenting plan submitted by Ms. Malave, and I'm just pulling up the case file here. And then as far as your position on the parenting plan, Mr. Aguayo, did you submit a proposed parenting plan to kind of give me an idea of what you're actually looking for?
I did.
When did you file it?
Either Thursday or Friday of last week.
Thursday or Friday of last week. And then did you?
I believe it was Friday.
Friday?
Yes.
Okay. And did you by chance provide a copy to Ms. Malave?
Yes.
Okay. So I'll tell you what I have in my file. So I have a response to the petition for a parenting plan that you filed, and that was filed on the 20th of September. So that was last Friday. So that tells me kind of your general response. And then did you file a separate document that is a proposed parenting plan that gets kind of into the details or the nitty gritty of the parenting plan?
Yes.
Did you file that on Friday also?
That's what I was.
I'm confused on which ones he has to file. I haven't done this for years, so.
Okay. So at the let me just quickly look at the minutes. So as a general rule, both parties will submit a proposed parenting plan.
Okay.
So Ms. Malave has submitted hers, so I know kind of the details about decision-making, holidays, concerns about substances or any restrictions, and it goes into relative detail. And then generally I'll have the other party's proposed parenting plan that has that same type of information, but from your vantage point. So that's the one document I was looking for, but I didn't see. I saw your response. Where
So we need another one to go along with that one.
Mm-hmm.
Yeah, we were.
Okay, we didn't know we needed another one.
Right. Okay, so then no, I'm sorry. I apologize. The answer is no to that. I did file one.
Yeah, so because otherwise I don't know what your specifics are related to those things. I mean, you expressed disagreement on a couple of the different provisions like paragraph 8 and paragraph 14 related to the restraining order and the like. But I don't know the greater detail that comes when a proposed parenting plan is filed. So that's one thing I'm lacking. Ms. Malave, I have hers. I know what she wants.
So what is it? Okay, so we'll just go up here and we'll ask, is the response?
No, you filed that.
So I have to propose one as well. Is that what you're saying?
Yeah, the proposed.
Okay, so I wasn't
plan.
aware of that. Okay.
So if there's a couple different options, if you type in a Google search, type Washington Court forms, and then type in form 140, or you can go to the clerk's office, 140, or you can go to the clerk's office and get a copy too. That's the parenting plan, and that's the proposal that we're looking for. So because at this point, there's a lot of detail that I think that needs to be fleshed out, and Ms. Malavia has provided that detail, and I don't know what Mr. Gual, your detail is. And if we have that, then we can have a more productive hearing when we come back next. Is that something you think that you could have that filed by end of